this topic is about whether the level of sophistication of an employee is relevant in determining the enforceability of a termination clause. So the brief background here is that in the Employment Standards Act, there are statutory minimums that are set out for notice and severance pay. Neither an employee nor an employer can contract out of the ESA minimum requirements. So if an employer tries to include a termination provision, which results in a lesser right or benefit to the employee than what the employee would have had in the Employment Standards Act, then the clause will be unenforceable and the employee will be entitled to a longer common law period of reasonable notice. So that principle is set out in a decision called Mattinger and HOJ Industries. And more recently, employers unfortunately have to deal with a decision called Waksdale and Swegon North America, which essentially says that if any provision in the termination scheme is unenforceable, then the entire termination scheme is unenforceable. I'm not going to get into detail about the legal analysis there. If you'd like to ask me either during the Q&A period or after the presentation at some point, I'd be happy to get into it. But just for now, understand that if any portion of the termination clause is unenforceable, then the entire termination clause is unenforceable and the employer is stuck with the common law. In a decision called Rahman and Canon Design Architecture, what happened there? The court had to look at whether or not the employee's level of sophistication should be relevant in determining the enforceability. So she was a woman of experience and sophistication. She was hired into a senior role at a fairly high salary. She had legal advice. There were lawyers involved in negotiating her employment contract. And she ends up with a clause in the contract which says here that Canon Design maintains the right to terminate your employment at any time and without notice or payment in lieu thereof if you engage in conduct that constitutes just cause for summary dismissal. I'm not going to get into the analysis in detail here, but I think it's fair to say that there is a general consensus in the employment bar that this provision would have thought to have rendered the entire termination scheme unenforceable, having regard to the Waksdale decision. In any case, the employee takes the position that the termination language should be unenforceable, and she's seeking a common law notice period. And Justice Dunphy found that the termination provisions did not contravene the ESA. And I've mentioned Justice Dunphy by name, in particular, just to tell you that he does have a reputation as being a fairly pro-employer judge. So if you are an employer and you see that, that Justice Dunphy is your judge, then that is good news. So in Rahman, the judge said, yes, this was a significant plaintiff. This was a significant, a sophisticated employee. This was an employer that got legal advice. I am upholding the termination clause, and the employee is only going to receive the statutory minimums. But then just a few weeks after Rahman, in two cases, one's called Livshin and the other is called Campbell-Givens, the court applied the decision in Waksdale and basically said, nope, the just cause provisions are unenforceable, the whole thing is out. So we essentially now have conflicting decisions about this issue, because in Livshin and Campbell-Givens, the court specifically held that the sophistication of an employee is not relevant. So here are the facts in Livshin, but essentially he gets terminated without cause. He takes the position that the termination provision is unenforceable, and the employer says, well, we think it is, but even if it's not, the whole thing doesn't really matter because, as per the Rahman case, this was a sophisticated employee, and the court should just accept what clearly was the intention here. But the court says, nope, sorry, doesn't matter. It's the language that matters, not the level of sophistication. So judgment for the employee. Same idea in Campbell-Givens, employee wins, okay? And the takeaway here is basically that a termination clause cannot comply with the ESA for some employees, but violate the ESA for others. It either violates the ESA or does not, and it is either enforceable or not. So this is perhaps the key quote to take away from Campbell-Givens. And I'll read it out to you. That the court found as follows: it is also problematic, in my opinion, to engage in a detailed analysis about the level of sophistication of an employee and whether or not they had time and opportunity to obtain legal advice. A termination clause cannot comply with the ESA for some employees, but violate the ESA for others. It either violates the ESA or does not, and it is either enforceable or not. So in other words, it's the language that matters. It's not about the level of sophistication here. So to conclude this topic briefly for you, so Rahman says that the level of sophistication of employees matters. Livshin and Campbell-Givens basically say no. So what do we do with that? I think it's fair to say that there's a general consensus in the employment bar that Rahman what was not correctly decided, in that it doesn't follow the Court of Appeal decision in Waksdale. So to be clear, the Court of Appeal is the highest court in Ontario, and the Court of Appeal's decisions are binding on lower courts, such as the Superior Court, which decided Rahman, Livshin, and Campbell-Givens. So probably going forward, Rahman should be seen as a bit of an anomaly, and likely the level of sophistication will not matter. But of course, if you are an employer, I don't think it hurts to take a position in line with Rahman and try and argue that your facts are as similar as possible to Rahman if you find yourself in this position. In order for termination clauses which limit an employee's entitlement to the ESA to be enforceable, they do really need to be drafted carefully. So we highly recommend that you speak to a lawyer in that regard.